your time. Julie and I'll just chat. So today's topic is going to be a really, 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 really good one. Really good one on survival tactics of getting through divorce, which I think is just spot on. And we always talk a lot about both the law and practically
Real life.
speaking. Real life, not just the law, because the law is just one tool, right, in our toolbox to handle the transition. So I love that we do that.
Yeah, and I think that that's a really old school approach, is just to go straight up litigation and that's it. And I've seen that with some of the lawyers nearing retirement, that's kind of the way that they were taught and what they do. But really just going the straight up litigation route can be dangerous.
I mean, it's never the most efficient ever, because some of the problems that you're going to face in your divorce are not really legal problems. They're practical problems. And then your legal problems could be solved sometimes practically. So, I think hiring, if you're going to work with a lawyer, working with somebody who's super creative and practical is 10 times out of 10 a better idea than somebody who's just like, I just want to fight, unless you're one of those clients who just wants to fight. And what's your best advice for those clients who are just like, I want to fight?
It's interesting. I was talking to a client yesterday, and he's mad. He's really upset about how he's been treated. And
Yeah.
he wants a moral victory. He wants to feel justified. He wants to feel like, yeah, there's right and wrong, and right is going to prevail. And I had a really long conversation with him just about what that looks like. If you're going to go down that path, you're going to spend tens of thousands of dollars in legal fees and costs. The outcome's totally uncertain. And let's really be honest with ourselves. Let's say you have the biggest victory and the court sanctions the other side, and you're proven right and the principle of the matter is proven. Do you really think the other side's going to suddenly see it your way? They're likely going to be like, oh my gosh, the system wronged me. He or she is such a jerk. And your point will not be taken the way you want it to be, most likely. So you're going to need to decide what's more important for you: staying enmeshed and engaged in this ongoing conflict, or cutting your losses and moving on. My mentor in the law, he used to always say, every lesson in life has its tuition.
Ooh.
So if you're fighting to try to get even monetarily, you're likely just going to keep throwing money at the problem. And sometimes we just have to admit that we made a mistake, whether or not it was our fault, and learn from it and move on. And that might mean, admitting that, you're not going to recoup all the money you put into the relationship or something like that.
Right. I mean, if we could just start by saying, you're going to come out at a loss. There is a price to get out of your marriage, whether or not you use lawyers, no matter what, there's going to be costs. And so trying to figure out, the fastest way out is usually the cheapest way out. Not always, but anybody who wants vindication and is looking for justice to be served will probably be disappointed.
The judge isn't going to see it the same way, most likely, won't take it as seriously as you do. And really what this is you're looking for some sort of external validation.
Mm-hmm.
And instead, can you go inside and get, learn your lessons and get your own validation, instead of going on a 6 month to 1 year, really fishing expedition, because proving your point is nebulous. Getting the court to vindicate you is nebulous. We see on TV these amazing courtroom scenes where there's these massive victories and justice is served and it's beautiful, but I've been a lawyer for almost 20 years, and those types of moments are extremely rare, especially in family court. There's almost never a landslide victory.
Almost never. And I'm thinking of one particular case that we worked on where these parties were married for more than 40 years. Husband was a pilot. Turns out he'd been living a double life. He
Oh,
had
wow.
another, yeah, he had another woman he was married to in China, I think. And it was we had huge waste claims. He had supported another family while he was married for 40 years. Okay. So those facts, like, they don't get better than that in terms of waste, but they wouldn't settle. We had to go to court. We ended up proving waste. She won, but she didn't feel like she won. Like, no amount. It didn't matter that she got what she was looking for from the courts. Nothing could repair the loss of the betrayal. And sometimes we're looking for the court to do that, to help fix the wound that we've suffered from our marriage, and it can't.
Yeah, it's really tough because you want that easy, not even easy, but that solution. And like that example you just gave, you can even get to the end point and then realize, no, that didn't do it for me.
Didn't do it. I won, and I still feel exactly the same. Still heartbroken, still empty, still angry, still with less money than I had before I was getting a divorce, even though I'm getting this waste claim. Still, it just, yeah. So what are some survival tactics?
Right. So let's talk about that. Let's talk about top survival tactics to stop getting triggered by your soon to be ex and reclaim your life. Why are we talking about this to begin with? We're lawyers, family lawyers. We should be talking about, how to file a petition or something like that. But what you'll find if you really get into the family courts is that you can't just run to court and get an immediate solution. I mean, yes, there are avenues for emergency relief, but they're very strictly defined. And you need to show irreparable harm, which is a really high standard. I mean, just imagine, wow, he may get hit, or my son may suffer emotional, there's a lot of speculation about what may happen, and that often doesn't qualify for emergency relief. You need to have some really strong evidence of irreparable harm. So you're not going to be able to just run to the court and get emergency relief in the majority of the circumstances. Plus, even if you go to court on a non-emergency basis, it's going to take months to get to a resolution. So the hot thing that you're really upset about now is going to, diminish over time. And then you may be disappointed to find that the courts want you to work it out. Like the judge doesn't want to figure out your parenting plan. And the judge doesn't want to be like, the person punishing which parent's the bad parent. Like the judge really doesn't want to do that. The judge will in certain circumstances, but they really don't. So what do you do when you're having troubles, like real significant problems in your life, but the court is not going to be your avenue of relief? That's what we're going to talk about today. What are your thoughts on that, Billie?
Yeah, I mean, what I think is hard about this is, unfortunately, we really do need to talk about what the court cares about and what the court doesn't care about, because unfortunately, I've seen a lot of people not go to court when they should have, and a lot of people go to court when they shouldn't have. And most of the time, more often than not, people want to go to court for things that the court doesn't care about. It is rarer that somebody should have gone to court or should have fought something and they didn't. But those situations that I see most often, both in my practice and online when I'm watching people discuss, is like, if you are a victim of domestic violence, this matters. You should not think the courts always go for 50-50. It doesn't matter that there's been domestic violence. I should agree to joint legal and 50-50. I disagree with that. That is not what the law says. That is not true. So I do not think that you should give up on that. And if you believe your child is in danger, I don't believe, and you've got like real issues. You've got an alcoholic parent. You've got a parent who's mentally ill. You've got real danger to your child. Not, he goes to bed too late, or he's feeding him, McDonald's too often, but he's not feeding my child, or whatever. Like, if it's really dangerous, then you need to take it to court. And if it's not really dangerous, then you don't take it to court.
Yeah, exactly. The emergency relief is there if you qualify, but there's going to be so many situations that feel like an emergency, but don't actually qualify under the law. And so definitely get legal advice along the way if you're facing what you believe to be an emergency situation. Go ahead, Billie.
Well, and even if it's not an emergency, even if your child is in danger, but you're not going to be able to prove irreparable harm. What I'm talking about is like, there's this belief that in Arizona, it's always 50-50 and it's always joint legal decision making. And that's not true. That is not true. Is there a presumption for equal parenting time? Yeah, there kind of is. But it doesn't mean that it's always the case. And it doesn't mean if in your situation that is going to be the case. So even if you don't qualify for an emergency. So what are some survival tactics? Let's say you're in that situation where you do have a danger to your children. You do not believe that long-term equal parenting time is the way to go. You currently have equal parenting time. What should they do?
Well, obviously, if there's been some incident that shows harm, then maybe you qualify to get emergency relief. So obviously explore that avenue if it's merited. But aside from that, you really need to check in, because especially if your kids are involved, the emotions will start running high, and you may or may not show up the best way that you could. And so anytime something happens that's, dramatic or upsetting involving your ex, I would encourage you to pause. Nothing good really comes out of just reacting out of anger or fear.
Mm-hmm.
Initial thoughts on that point, because it's so easy to respond to the trigger right away and just, explode really.
Absolutely. Like, how long do you think people should wait between? Well, okay. So one thing is, if you're pretty heightened, you and your ex are pretty heightened, and you guys are fighting, and the heat is on, I recommend stop texting. Stop any immediate forms of communication. Slow down. If you get out of phone calls and you get out of texting and you just move over to email, you're immediately going to slow down. You might even need to take that a step further and say, I'm not going to respond to this email for 24 hours. And sometimes that will help you as well. I'm just going to close the door, but what do you think about that? Like, what's a good response time?
Yeah. First of all, don't fall into this trap that you have to immediately respond to everything. There's a time and a place.
Right.
If you're getting a message, hey, I'm taking our son to the hospital because he broke his leg at soccer. Yeah, respond, sure. But if you're getting somebody who's like throwing lies at you, like, oh, you didn't get our daughter to school on time, and you didn't do her homework, and she had dirty clothes, and it's just like all this stuff that's not true. And the first thing you want to do is like fight back. That's where I would take a pause, because that's when you're falling into their world.
Yeah.
You're losing your power because now you're getting all upset and you're getting triggered and you're falling into it. But really, there's no emergency here. These are lies. This is stuff that can be addressed. And the other side also needs to learn to communicate with you differently. And if you're going to just engage right away and throw back or get into this fight with them, you're really not changing anything in your communication dynamics.
No, and you are giving them what they want. If they're spewing venom at you, You're a terrible mother. This shows how much you actually care for our child. If you blah, 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 you always blah, 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 blah. That is what they want. What they want is your anger and your hurt and your energy and your emotions. Like, the best thing you can do is just refuse to engage, give them nothing. It doesn't mean you're not going to set the record straight, because a lot of people worry, but don't I need to respond? If I don't respond, will they think that I've admitted it? You have all day and 3 weeks. You could respond anytime you want, in any way. You could respond, 48 hours later saying, none of this is true, period. Not justifying yourself, not proving them wrong.
Yeah, definitely. Don't feel like you always have to prove yourself right. A denial can be enough.
Yeah.
You can just say, nope, not true.
Yeah.
You don't have to get into this long protracted texting thing that's taking you away from valuable time with your kid, and you're all angry and upset, which your kid knows, like they feel it. They totally get it.
No.
No.
And
this is, yeah, go ahead.
If you are going to end up in court, if you know that you have a court date, you do need to be prepared to offer evidence to the contrary of whatever's you're being accused of. But it is not the time to tell the other party what your evidence is or what you plan to show, or try to convince them that you're right. It's not going to happen. So take this as intel. Think about this as discovery. You've discovered what it is they're going to say about you. And now you need to think about how you're going to combat that, should you need to. But right now is not the time you need to.
So one technique to start, releasing yourself from these triggers is, when it comes up, pause and observe how you're feeling. Check in with your body. Are you feeling it in your stomach? Is it in your chest? Is it in your neck and your shoulders? Is it your face? Like, where are you feeling the upset? And that's going to help you really just start to recognize how this person is really making you feel. I mean, obviously, you know that they upset you, but when you can check in with how it's manifesting in your body, sometimes that can be a really big wake-up call. Like, wow, I need to stop feeling this way. I'm getting divorced for a reason, or we broke up for a reason. Why am I still trapped in this emotional bond with this person?
Yeah. Totally agree. Checking in with your body is great. Like, I find that sometimes I'll carry it in my jaw. My jaw will get really, really tight, or here. And taking your 2 feet, planting them on the ground, and doing anything bilateral really, 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 really helps ground the body, really influences the nervous system, which allows our brain to be its best self. Like, this is not woo-woo stuff. This is like just literally like we're whole human. We're not just our emotions and our brain, our body and our brain. It's all connected. And so we have the ability to go move. The other thing, I've got some people on TikTok who are making some really great boundary statements. And if you are on TikTok, there's some people you can follow who are just great at boundary statements. And they have these 10 one-liners, and they're so brilliant. Things like, did you mean to say that out loud? Or the one that was brought up here was that, I understand that's your perception, but that's just not my reality. So just those boundary statements can really help you if you feel like you need to say something. You cannot walk away without saying something, although no response is sometimes the most powerful response. Another alternative would be figuring out how to just walk away. But the thing is, if you always feel like you have to have the last word, you're never going to be able to, that will never end. So you have to, I think, challenge yourself to be comfortable not having the last word.
And really what that comes to is, you are going through what the other side's thinking, or feeling like you have to win for the other side. It's all about the other side. So if you could just check in with yourself, and give yourself the last word, and it doesn't really matter about the other person, that's a huge shift that's going to help you start detaching. And this body scan is really helpful because it breaks the pattern. Like, instead of just
Mm.
going to the response text or getting mad or wanting to have a drink or, whatever it is that you want to do when your ex is upsetting you, this check-in really helps for you to stop that pattern
Mhm.
and slow things down.
Mhm.
And then, once you've started to recognize how this is impacting you, you can start analyzing, like, how long do I want to stay here? You can't change, like, you're not necessarily going to be able to get the other side to stop being mean. But do you have to get upset every time they're mean? Do you have to care what they think or say? And that's really about cutting these ties, because whatever relationship you were in and for however long, you likely built this dynamic between you, and now you got to shift out of it. And so even though it's easiest to say, oh, they need to change and they need to do this or that, that's really just putting yourself in a tough cycle where you're going to get stuck. But how about you change how you show up in the dynamic? Billie, can you talk to about that a little bit? Post divorce, you're not in the same relationship with your ex. So how are you communicating differently?
Yeah, I do want to talk about that. But one other thing I want to say about what you said, not only will this changing the dynamic and not, removing your role in the dynamic, not only will it make you healthier and happier in that moment and long term, it will also help you show up in front of the judge better. It will also help you make your legal case. Oh, people calling. No, thank you. So you asked, how is the relationship dynamic different post-divorce than it was, during the marriage, and then in that time period when you're going through divorce? I'll tell you what. So, your marriage usually starts off pretty good. Things are fairly functional for a certain period of time, and then they begin to get more and more dysfunctional leading up to your divorce. When you go through your divorce, it is not like a one-day thing. You've got like a period, a breakup period that I think is probably for most people a period of years.
Mm-hmm.
And during that period of years is when you're going to be at your most toxic, the two of you. It's going to be the most dysfunctional leading up to the divorce and then going through that divorce period and then maybe even a little ways out of it. But I think it's kind of like a curve, right? So if you start off and things are pretty good between the two of you, and then they decline, and then they get really, really bad and they stay bad, they're going to start getting better as the two of you start rebuilding your own lives. Depending, the less contact that you have, the more you can break your dynamic and your routine of fighting and inputs to each other, the better the relationship gets. And I sort of think about my ex now like an extended family member that I don't particularly love to spend time with. Like, I would not call us like friends, but he's around and he's not going anywhere. And you need to want the absolute best for them. Like, I want him to be happy and healthy and successful. And I have to be polite and properly attentive like you would an extended family member, because I don't know, I just kind of feel like you owe that to this person. This is the parent of your children. Your children are half of this human. Like, I think we owe a certain amount of respect and politeness to this person. I don't know if that answered the question.
Yeah, definitely. It did. It's a major shift in how you relate to each other.
It is.
And it's really releasing a lot of those emotional attachments. And something that can come up is, maybe you've moved on, but the other side hasn't, and you're getting like a lot of jealousy and clinginess and things like that. What are your thoughts on dealing with that situation?
I mean, yeah, I think that that can be really hard. Um, if one person feels possessive, and then I think it can be really hard if there's a religious component, to your marriage, because if there's a religious component, it just makes things more complicated. I was meeting with a client yesterday who they've been separated a year. He really wants a peaceful divorce. She will not, move. And her position is, divorce is wrong. You are my husband. You owe me. You have left and you've done wrong by even leaving and trying to separate. And you better come back begging. And this person feels like they will never submit to a divorce because they're married and they're married for life. So if you come from a household where there's a religious component and you believe that you've entered into a covenant and you're married for life and that's what God thinks, there's a possessiveness that the religious thoughts can kind of encourage, and it's not healthy. Because I mean, regardless of your beliefs, that's just not how it works on earth. This person does not belong to you. You have no right to be possessive over them. And so if somebody is feeling possessive towards you, how do you set the appropriate boundaries? I've heard of women who've, been separated, and their ex-husbands or ex-boyfriends will come up to them and like open up their shirts and look at them naked, and they feel like they're entitled to do that. And so I think if that is where you're at, right? If there is that level of jealousy, and being with this person or near this person makes you incredibly uncomfortable because they're objectifying you, or they're treating you as if you belong to them and you're their possession, I would probably try to just limit all contact.
Yeah, you want to have very clear messaging. Don't be, oh, well, I'm sorry, and maybe we can get coffee. And like, no, you're going to have to really set some really clear boundaries and minimize communication. And then if there are, communications, I would be, very clear, you need to let me go. True love is actually letting the other people go. It's not hanging on for dear life. And just keep hitting them with reality. And
Yeah. It does not, a good co-parenting relationship does not require you to be friends, does not require you to hang out with one another, does not require you to be to celebrate holidays or birthdays together. And I really do not advocate for putting that in orders at all, because there might be times when you can celebrate together. And then there will be other times where the relationship is not in a place where it benefits your children or anyone for you all to be together. So I think if we're still in a possessive phase, like that relationship needs to be like real broken. Like you need almost physical boundaries, like space boundaries away from somebody who is possessive and jealous over you.
as you're going through this, another tip is, don't go through it alone.
Mm.
Connect with a lawyer that can walk you through strategies to implement, or, file court papers for you if needed. Consider therapy for you and your kids, even family therapy, depending on the dynamic. Um, Find a trusted friend, a sibling, a parent, somebody who you can just totally vent to. Like when you have all of this anger and stuff, it's nice to be able to go to mom or sister or brother and be like, man, my ex made me really mad today, and this is what happened. And, they could be there for you. Um, and I like to find the people that just listen. Sometimes I don't want the solution, and I don't want, oh, well, then do this and then do that. Like, can I just vent? And can you just hear me and commiserate with me? And then I can move on. And sometimes those are the best people, other than the people who are always looking to like make you better.
Yeah, especially when you're in the thick of it. Like you just, it is really good if you're going through a divorce to find some new friends, because most likely if when you're married for a long time, your friends are couples and they don't get it. And they want you to get back together because their friendship is with both of you. And so they have some sort of like allegiance to the marriage, and that's understandable. It's human nature. It's okay. But it's going to be really good for you to get around some friends who understand what you're going through. So find some friends who are going through a divorce, who have been divorced, and they will support you. But I agree with you, you don't need the fixer friend all the time at that point.
Mm-hmm.
Time and space and the ability to vent, like almost like the friend is the journal. You pour into your journal doesn't tell you what to do back. So
yeah. And Billie, if you are getting comments from the audience, I was wondering if people could tell us, like, how do they feel when they get triggered? Where does it show up in their body? Like, what are their thoughts about these situations and how you deal with it? Are they just getting caught up in the trigger, or are they starting to implement some new tactics? Any comments?
We have lots of comments, lots of questions. One of my favorites here is from Mommy is Not Silent on TikTok. And she said, we both know that is not true. That's her favorite line when she's getting garbage. I like that a lot. And then this person said, in the time that we do fall into the tit for tat, does that look bad on us in court? I mean, it probably depends on the degree. And most of the time, this is not going to get in front of a court. Most
exactly.
of the time. One person said they just let their ex blow up, just do it. Another liner is that may be your perception. It doesn't make it reality. Yeah, just good stuff. And then we do have some questions here. Okay. If the father of my child is filing in court and filing claims against me that I feed our child fast food and our child didn't go to the dentist, and he has a list of concerns and he's filing for custody, what will the judge do?
All right. So first, the quick disclaimers for the Q&A session. Billie and I don't become your lawyer by doing the Q&A. Our answers are just legal information. We can't give you specific legal advice. We'd have to sit down and really get into your full situation. And this is based on Arizona law because we're both licensed in Arizona. With that said, the fact that he filed the petition is something you're going to have to deal with. And I'd be going through each allegation and starting to build a defense. And even if some of the allegations are true, but they're not good, I would be making changes. But, you kind of have to look at, well, what's good or bad? Like, is the judge going to change parenting time based on how much McDonald's is consumed? Like, I've never seen a parenting time order based on McDonald's. So I would have a really hard time seeing any judge base a parenting decision on fast food. What were some of the other allegations? Dentist?
Didn't go to the dentist.
Yeah, relevant. If you missed one dentist appointment though, happens. If the kid's never been to the dentist and has some dental issues, again, I would be looking to solve that.
Yeah.
But again, is the judge going to bring the hammer down because some things fell through the cracks on the dental work? It really depends on the situation, but likely no, if that's the only thing. And
right.
A lot of these things that are coming up are stuff that the court is going to say, parents, you need to communicate and figure this out.
Yeah, it really doesn't matter how much fast food you feed your child. It does matter if your child is extremely unhealthy and has health problems and you're unwilling to do anything to help them in their health problems. You're not following a doctor's recommendations. Your child is suffering. What if your child has, let's say your child has type 1 diabetes and you're feeding them sugar and you're not monitoring their insulin levels? That matters. It doesn't matter how much fast food your child is eating in and of itself. And with regards to the dentist, if you are not taking care of your child's needs, if they have an infection in their tooth that needs to be taken care of and you're not, I think that matters. If you miss some appointments, I don't think that matters at all. If it's not impacting your child's health, go to the dentist. That's the other thing. A quick and easy way to handle that is just to go to the dentist, and then if that issue is resolved, it's resolved. So these are the types of claims. I love these examples because this is kind of exactly what we're talking about. You kind of put on your lawyer hat and think about, what is the judge looking for? A change in circumstance and best interest of the child. So is the fast food and the dentist thing a change in circumstance or not? If it's not, you might be able to get rid of it with a motion to dismiss. And then best interest. If your child is thriving, then these things don't matter to me. If your child is not thriving, if your child is struggling, then the accusations, I think, have a lot more weight, or could have more weight. And you may want to take some proactive measures to get out in front of that issue. Have you had that come up before?
As far as just minor things all being thrown into petition, or I mean, yes, I have. Recently, a mom just ran to the court and filed some papers saying she was upset about a schooling issue. And the court ended up just summarily denying it on its own because it wasn't done correctly. But, I think that the person who wrote in the question, if dad is really just, being unreasonable and really trying to just cause problems for whatever motivation he has, I would be trying to set dad up as a vexatious litigant, somebody who is not, following what the court wants, which is first talking to the other parent and trying to resolve stuff, but just running to the court. And so I would be trying to really get some language and some final orders, really attacking dad for his tactics, if possible. Because another thing that I found is, if there starts to be an order or two within a history of a case, because, family law cases can go on for a long time, that has really adverse findings against a parent, it can be really hard to overcome those, even if you have a new judge, even if circumstances have changed.
Yes.
So even if things look really bad and the other side's attacking you, if this stuff isn't true and you're able to show that and get some final orders that are saying, oh, dad is an unreasonable litigant and things like that, that could be beneficial down the road as well.
Yeah, that's a great point. A great point. Next question. How do you get your husband to sign a settlement offer? He's put it off for 2 weeks. Trial was extended. He verbally agreed to sign. He's continued to relapse on drugs. He's finally in treatment. And I know his sobriety is the number one top priority, but I've been waiting and I just want to move forward. What can I say to nudge him without angering him or overwhelming him? He'd often tell me not to control him. Should his lawyer nudge him more than I? And then she also followed up, I have a protective order, but I'm still trying to be polite. He and his attorney continue to state that me being polite during minimized communication about the children means I'm not scared of him and the protective order should be dismissed. How do I manage the boundary? There's a lot to that question.
Yeah, and it's kind of hard to answer. Like, if I had been involved in this case from the get-go, I'd probably be like, okay, let's try this tactic and let's try that, because I would know the players a lot better. So again, this is just information. Like, I don't know all of these players and I don't know what would be the best tactic, but I would definitely be going through his lawyer and saying, hey, look, if you're not going to sign this by this date, I'm going to have to call the court. I'm going to have to file a motion with the court asking the court to set another hearing and enforce, if there was an order for him to sign, to enforce that order. And then also maybe talk to the lawyer about coordinating. If the guy's in treatment, see about getting the papers there. They usually have, a notary on staff. I don't know. They usually have some stuff that makes it so that everything can be done right there. And I would be looking at that angle too. I think you need to be a little cognizant of as well of where he's at on his sobriety deal, because you don't want him to come back later and be like, I was under duress and I didn't know. And so pushing too much at this exact time could be problematic. And you may just want to let a little more time pass and see what happens with him with his sobriety. On the flip side, if you think he's going to be out of this sober house and he's going to be back using again, then maybe this is the time when you need to really push to get the signature. So it's hard for me to analyze this without really knowing, without being a part of the situation. Any thoughts, Billie?
I mean, I agree. Trial's been put off. There's purportedly an agreement. I don't know what that agreement is. I don't know if that agreement is super favorable to you or not, especially given the alcohol or drug issues. Like, it's very difficult for us to answer that. But I do want to talk for a minute about the second part, about a protective order. So if you have a protective order against your ex, how should someone be communicating?
Well, if he has a lawyer, you can communicate through his lawyer. And so that's what I would do. There's also an exception in the protective orders for communications about legal stuff. You can really get the specific language in there. So there is an exception for, going to court and doing legal stuff and getting a signature on a decree may fit within that provision. But again, if he has a lawyer, I would be going through the lawyer. And then if the lawyer is giving you a runaround, I'd be going to the judge and be like, Judge, this is what happened when I went to the lawyer, and this needs to be done. Like, we reached an agreement. Getting the judge involved may be a very useful tactic in this situation, because the judge wants the case closed too.
The judge absolutely wants to sign your agreement most of the time. The other thing I'm reading between the lines here is sometimes when you've had an addict as a spouse, you can be in a very codependent relationship. Mm-hmm. You can feel very responsible for their sobriety, for their feelings, for their wellness, for their level of functioning. And I'm not saying this is you, but I'm reading that this could be an issue where you're feeling like you have to be a support for him. And that supportiveness as politeness is coming across as you don't actually need a protective order. You're this person's friend. So I think that can be a very tough situation. You don't have to prove you're in fear to keep a protective order in place. They now last for 2 years. So that's been extended. So now if you get a protective order, it's in place for 2 years. If you want to get it extended, it's generally hard to do without a new incident of violence. And whatever happens during those 2 years, if there's pages and pages of text messages between the two of you and you want to extend it after the 2 years, and they use those text messages to say, like, this is unnecessary, that might be evidence that it's unnecessary. So I don't know what else to say about that.
One thing I want to add is I'm putting together the order protection course. It's almost ready. Nice. So that'll get added to the members area soon. And it goes through just the start to finish overview of how to get an order protection, how to contest one, what happens if there's mutual orders filed. So there's a lot of different information, and that's going to be available to the members shortly. So I know orders protection come up quite a bit, and the court continually tries to streamline the process and make it easier, and they've done a really good job, but there's still some nuances, and there's trial aspect to it as well if a hearing is requested. And It's a full trial. I mean, it can be short, but all the same trial procedures apply.
Mhm. Well, and they have their own rules of evidence. They have their own rules of procedure and they have their own rules of evidence. So I'm so glad that we've got a designated course on orders of protection available in the members area. The members area is now open, which is super exciting. And what do people get when they join the members area?
So, right now we're getting ready to launch the classes in January. So this is just the early bird access to start getting your feet wet with some trial skills, with some of these mini courses we're going to be putting in there on various different issues. And then there's also other free resources, or not free resources, but resources within the members area that cover various aspects of divorce and custody. And that'll all be leading up to the classes starting on January 9th. So Mondays, we'll be talking about divorce. Tuesdays will be about custody. And then Wednesdays will be about modifying or enforcing a custody order or a divorce decree. And then on Thursdays, we'll be talking about trial skills and practicing them. So each day has a lecture component, but then also the Q&A to get your questions answered. And that'll be a 10-week course starting in January.
That's so exciting. It's very, very exciting. And if you're interested, but you're kind of unsure, I think we have the first 2 lessons available on Modern Law's YouTube page. And the trial skills course is 10 different lessons, all really, really good if you are headed into court and you need to figure out how to represent yourself. Really, really good information. Let's see, a couple other questions here. My ex didn't show up for mediation and compared the error of our holiday time to the same for the error that he shouldn't have to pay child support. Okay, so what I'm reading is maybe mom took dad's holiday time and dad didn't pay child support. And then he didn't show up for mediation. I don't know if your mediation is required before you do an enforcement action. Maybe that's what we're talking about. I don't know. There's not a lot of information there.
So, right, if the court ordered him to attend the mediation, there could be some repercussions from the court. Nothing too serious, but they might, give him a little slap on the wrist. If he has a reason for missing it, something he got COVID or, something like that and couldn't go, the court may reschedule it. So even if you think he's lying about the reason, the court may be like, okay, I'll take that, go back to mediation because the court just wants you to try mediation. So it's possible it could get rescheduled. There is no direct connection in the law between exercising parenting time and paying child support. Child support is due regardless of what happens with parenting time. So he can't just decide not to pay. And if this case is through the clearinghouse, that non-payment will be recorded and interest is going to accrue, and they could take his tax return and pay you that way. I mean, there's some different options, but one of the biggest things here, I mean, if he was through the clearinghouse, he wouldn't be able to just say, I'm not paying. And that's kind of the point, is if you can get your case so that child support is through the clearinghouse and the payer is an employee and their wages are being garnished, it's a system that goes forward regardless of what's happening between you and your co-parent. So I would be looking to get that child support order through the clearinghouse so that he can't use it as a means to punish you if you guys reach a disagreement on parenting time.
Mm-hmm. Yeah, she did give us some more information. He didn't give a reason. The court says they will charge him $100 and I can try to remodify child support. Okay, another question I've got here is about expert witnesses and the process and the benefits of hiring one for a high conflict case.
Yeah, when you have a trial, if you've got dad testifying and mom testifying and that's it, it can be really tough for the judge to make a decision because your evidence may be somewhat equal. And it's just a real toss up between who the judge decides to believe, or whose proposal the judge decides to adopt, or maybe the judge does something in the middle. Um, and that's where an expert witness can really help to change that dynamic. And instead of it being a he said, she said, now you have an outside third party who can come in and give an opinion that can actually make things, much more persuasive. But you really need to figure out, okay, what am I using the expert for? What kind of report is going to be generated? What's going to be in there? What are they going to testify to? Is the other side going to get a counter expert? Are we going to have a battle of the experts? And kind of if this is maybe something about a child, what's happening to the child along the way? So a lot to consider, and experts can be pricey too. So there's a lot to consider with getting an expert involved. What are your thoughts, Billie?
And I love expert witnesses. I do. I just generally think that they can be incredibly useful because judges obviously have their own biases, their own inclinations, their own framework that they see the world through. And they have a lot of discretion. So especially if you're going in front of a judge, let's say you're going in front of a judge who always gives equal parenting time. That's what they do. That's their belief. And you believe that in your case, it would not be in your child's best interest to have equal parenting time for your particular child. In that case, I would think that it would be very useful to have an expert say why your child would not be served well with equal parenting time, because the judge has to consider the evidence. Now, that does not mean that the judge has to agree with your expert, but they have to consider the evidence, and that would help you or could help you. It's hard though, because judges largely, because they have so much discretion, can do whatever they'd like.
Yeah, I mean, if you're looking at expert witnesses, you're probably working with a lawyer. So, keep working with your lawyer on that issue.
Let's see. Another question we've got is, let's discuss legal decision-making with final say.
Yeah, there was some case law on that within the last few years. And the question was, if we have this designation of joint legal decision making with one parent having final say, aren't we just awarding sole decision making? And if memory serves, the court said, no, you could do it that way and it still is joint.
Yes.
I have a hard time with my clients selling the final. I mean, obviously the parent that wants it, you don't need to sell anything to them. But for the other parent, I have a really hard time getting that agreement into place. Generally, we'll just end up saying joint. And really, I like to break it down. People think of decision making as covering everything, but it doesn't.
No.
It's education, it's healthcare, it's religion, it's personal care decisions. So I'm really looking, okay, where's the dispute here? Is it education? Is it healthcare? Is it religion? Very rarely is it religion these days.
Mm-hmm.
And then personal care is so nebulous like that. That usually doesn't come up. So it's either education or healthcare is where the rub is. And then that's where we're looking to get some really clear language on just those issues that are in dispute. And it may or may not involve mom or dad being a final decision maker.
Yes. Yeah. I think when you have children with ongoing medical or educational needs that are unique, or just not, anything other than a very healthy, very average, very well-adjusted child. If your child currently takes any medication or sees any specialists or is on the autism spectrum or whatnot, and there's high conflict, I like to build a parenting plan that reduces deadlock, because joint legal decision making can create deadlock, and deadlock seems to favor the inaction versus action. So if my client, usually it's moms who have taken point on therapy and decision making, and if there's a high conflict divorce and dad now wants, the hard part about this dynamic is mom's used to making this decision, she just wants to make the decisions. Dad had previously given her this authority, she feels like she's the most qualified, she just wants to make the decisions, and now dad's like, but it's different now, we're divorced, I get to weigh in, and he's right. But I like to figure out ways to reduce deadlock, which might mean I put into the parenting plan that the parents are going to continue to use the healthcare providers they've got and follow any recommendations for the future, or something like that. Or decisions like they're going to continue with XYZ treatments and X school, and won't make any changes unless blah, blah, blah. So really trying to get in front of major decisions like you're talking about, I think is a good thing. The other thing is, if you have parents in different states, I think it's a good idea for the parent who's driving the kid to school every day and watching the kid in school every day to have the final say. Let's say the parent moves within where they're at. Like, I feel like letting the out-of-state parent block that decision could be a problem. So I really try to think about what's going on in each individual case when negotiating and crafting the right parenting plan.
Yeah, definitely.
The other thing that comes up is counseling. One parent wants to get a kid counseling and the other parent refuses. How do you handle that?
So I definitely want to get the refusal in writing, because if we are going to go to court, I want to be able to show the judge that this parent is objecting to getting the child help. I'd also like to try to get some reasons why, if any, and possibly open up to a family counseling. Say, look, if you have some concerns, why don't we set up a family session and see if everybody can get involved? Have the other person have some say on what counselor gets selected. That is a bit of a slippery slope. So you've got to analyze the situation to see if you want to open that door or not. Those are some of the things, but it can be tough. And usually the objection is that they think the counselor is going to turn the kid against them somehow or something like that. And, in practice, the counselors generally don't come to court. I've seen a counselor to come to court here and there, but it's very rare. There's the counseling records, and sometimes they're helpful, sometimes they're totally vague, sometimes they're not correct. So in practice, yes, the counseling can be very valuable, especially if the counselor reaches a conclusion that one of the parents is not safe. The counselors are mandatory reporters. They would need to call DCS. But yeah, sometimes you have to get a court order to order counseling if the other side just absolutely refuses.
Yeah. And if the reason you think you need final say is because of that, which happens, somebody might say, I need final say because I need to get my kids in counseling. The other thing that you could do is write into your parenting plan that either parent can take the kid to counseling. So there's some ways you can get around this final decision-making issue by building in what you need immediately. So we are out of time for today. How do people register and become members?
All right, visit winwithoutlawschool.com and the information's there. If you have any questions, you can email info@winwithoutlawschool.com. And we look forward to teaching you how to have success in the courtroom without a lawyer.
Great to see you, Julie. Talk to you soon.
Bye.
Bye.